Good morning. Good morning or good afternoon, depending on your location. My name is Tamara Dini. I'm a competition lawyer from Bowmans, based in South Africa. I'm also a co-chair of the Antitrust Law Committee of the International Law section of the ABA. I said I would get myself a reward on the way home if I got that sentence right. It's great to be participating in today's brown bag, and I look forward to hearing from our very distinguished participants to be introduced shortly. Today's topic is African competition law looking ahead. As many of you will know, there have been significant developments in recent years in competition law regimes across Africa. This brown bag will focus on key areas and highlight what to expect going forward. We'll be looking at COMESA, Kenya, Nigeria, South Africa, and the African Continental Free Trade Agreement. So that is a lot of ground to cover, and without further ado, I think we should get started. I would like to firstly Dr. Willard Moya, the Director and CEO of the COMESA Competition Commission. Thank you very much for joining, Dr. Mwemba. It's really lovely to see you, and I appreciate your time. I know how busy you are.
Thank you for inviting me. Thank you for inviting me, Tamara. Thank you.
And then we also have Mr. Wangombe Kariuki, the former Director General of the Competition Authority of Kenya. A big welcome, Wangombe. Thank you very much for joining.
Thank you, Tamara. It's my pleasure.
Thank you. We're also joined by Ms. Florence Abebe. Florence is the Chief Legal Officer of the Nigerian Federal Competition and Consumer Protection Commission. It's really great to see you, Florence, and a huge welcome.
Thank you so much. It's my pleasure.
Thank you, Florence. We'll also soon be joined by our fourth speaker, Mr. Amanda Mfupi, who's a partner from Bowmans in South Africa and a former member of the Mergers Division of the South African Competition Commission. Amanda is speaking at a panel for the ICN, I believe he'll be joining us from the US in a short while. So if we start, if I may, Dr. Mwemba, to turn first to COMESA. And earlier this year, the COMESA Competition Commission celebrated its 10th year of operating, something I remember phoning you incessantly in 2013 and apologizing, because I think everybody was phoning you at that time. And you were always so polite and said, it's my duty as a civil servant to be answering these calls. And I knew there were so many people trying to reach you at that time. It's really great to see you, and congratulations on the Commission having emerged as a strong and respected regulator over its first 10 years of operating, moving first from mergers, now more recently into conducting investigations into prohibited conduct. And so huge congratulations, and the Commission going from strength to strength, and importantly, being seen as a transparent, pragmatic, and fair and accessible regulator. Now, I think you've also succeeded in creating a one-stop shop for merger control across the 21 member states. As I understand it, and perhaps that's how I'd like to believe it, almost all member states, or all member states, recognize the COMESA Competition Commission as a one-stop shop for merger notification. Is that correct, or is that something you would like to comment on?
That is correct, but yeah, you want me to comment on it now?
Sure, please go ahead.
Okay, no, that is correct, Tamara, and in fact, I'm very glad that I'm sharing this platform with my big brother Francis Wangombe Kariuki, because I think he really contributed very much in his time as Director General of the Competition Authority of Kenya, who really ensure that COMESA indeed has a one-stop shop. And some of the things we did with him, in fact, at his initiative, we ended up replicating it to other COMESA member states. You will recall that when we commenced our operations, I was looking at some of the pictures of those times you were mentioning, and when I look at that picture and I look at myself today, I don't believe it's still me in those pictures. But yeah, that is how time has passed. So you will recall that then we had issues with Kenya. And at that point, I'll be very honest and very frank that we thought of Kenya as being a prodigal child. But later on, I understood what Wangombe Kariuki was trying to do. He was saying, yes, we agree with this principle, but let's put in place things that will assist to sustain this principle. Let's not just talk about a principle that is not sustainable. And I think at the end of the day, Kenya and COMESA ended up creating a system that stands the test of time, which system was replicated to other countries. So I'm glad today to say, indeed, we have a one-stop shop. I know there have been questions on Tunisia, but you will recall that Tunisia, and your colleague Tolani has actually asked me that question on Tunisia. I've not yet responded. I apologize. I think I'll take time to respond now. But I hope he's watching this podcast. You will recall that by the time we were coming up with that framework with Kenya, which ended up being replicated to others, Tunisia was not a member state then. Tunisia came in quite late in 2019, and then we had all those COVID issues. So principally, working with Tunisia commenced around 2021, trying to put in place similar frameworks. I would say with some confidence here that we are at an advanced stage. In fact, the government of Tunisia has invited me in Tunisia around mid-December to go and come up with a framework that will ensure also a seamless system and working between the Tunisian Competition Council and the COMESA Competition Commission. So for the other member states without Tunisia, 100% one-stop shop. Tunisia, they are on the bus. They've invited me to Tunisia to go and sit down with them, discuss with them how this thing then should work between us and them. That's where we are. Now let me go to the topic of you have a question, Tamara?
No, I just said that is excellent. And I was going to ask you about when you finish, Dr. Mwemba.
Okay, thank you. Now, let me go to the business of the day. First of all, thank you very much that you've invited us, and we are thankful. We are appreciative that our works in contributing to the welfare of society in the common market is actually being recognized and appreciated. Indeed, when we commenced, we were quite very major eccentric, but now we intervene in a number of issues, as you rightly observed. Conduct cases, we have a number of them now, but not just conduct cases, also informing law and policy in a number of our member states. We've informed lots of law and policy reform in a number of member states. Some of them result in complete overhaul of their legislation. I know we're doing that in Djibouti currently. We're doing that in Ethiopia. We're doing that in Comoros. We're doing that in Malawi. In other countries, we are not doing the complete overhaul of the law, but we are doing amendments in their provisions so that, again, the one-stop principle that you're talking about is completely cemented in legislation. So Zambia is one of them. Eswatini, as you may know, Tamara, we already did that. They put some provision in their law that expressly recognizes the jurisdiction of the commission. So we are happy that we are doing all that work, and that we've moved just from being a merger-centric competition authority to a competition authority that addresses all issues in as far as competition regulation is concerned.
Super. You're certainly very busy. That's great to hear, Dr. Mwemba. Thank you very much. And what would you think are the challenges that lie ahead for the COMESA Competition Commission, having done your initial 10 years and so successfully?
Yeah, the challenges, the word challenge is a very important word. And I think we have challenges in every aspect of life. I'm yet to find a person who say in this area of life, there is no challenge whatsoever. So challenges will always be there. But I think the biggest challenge that gives me a sleepless nights, and a number of stakeholders have spoken about this, is the dismantling of cartels in the 21 COMESA member states. It is very evident that cartels are very rife in the common market. Cross-border cartels, I should say. That becomes very difficult for each individual national jurisdiction to really address, because some of them are happening in Zambia, but they are having effects in Kenya, for example. Currently, I think you have, Tamara, that we are doing a study called the African Market Observatory. So basically, we are looking at competition concerns in the agri value chains. And we have, on the preliminary basis, obviously, I'll not get into details, seen a number of serious concerning issues, cross-border nature of certain conduct initiated in one country, having effects in another country. I'll talk about Kenya, for example. Some time back, we did see quite terrible droughts in Kenya that affected their harvest and the grain. There was shortages and it ended up resulting in skyrocketing prices, the grain that is used in animal feeds, for example. And then as we looked carefully, we did realize that if the market was competitive and if there were no distortions, there would have been no reason for Kenya to suffer those high prices in feed markets, because there were products in other countries, grain that could have easily entered Kenya if there are no competition distortion or market distortions, and that could have stabilized the prices there. So to me, that's the greatest challenge I see, figuring out how to dismantle these cartels that are evidently there. And when I say figuring out, I mean, how do we at state level come together in terms of the investigations, giving out evidence, maneuvering around the jurisdictional issues so that we successfully prosecute these cartels. As you may know, cartel prosecution, the standard of proof is actually very high. So it's the evidence that should be adduced should not be on a lower balance of probability, but quite a high standard. And you cannot just go in casually there without doing your your homework. So that is what is troubling me. But I'm glad to state that I think we're moving in the right direction. Currently, the Commission has some investigations involving cartels, some of them at an advanced stage. And I think once determinations are made, we will be able to share with the public. The other one that may be of immediate challenge to me is what the interaction will be with the imminent Africa Continental Free Trade Area Competition Protocol and the imminent competition authority there, and how we are going to ensure that we don't create uncertainty, which Wangombe against was much against when COMESA was born, that we don't need to create uncertainty. We need to come up with a system that is that does not confuse business. So I think we are at that point again. How will the COMESA Competition Commission, the National Competition Authorities, work with the AfCTA so that we do not create this uncertainty, which is not good for business, which is not good for business investment. So I think that is one of the challenges, and it is good that we start thinking about these issues immediately before we reach there, so that by the time we're reaching there, that uncertainty on business is completely not there. The other one is making sure that all our governments appreciate the important role competition law plays in poverty alleviation and economic development. I'll be very honest, and I don't know what colleagues like Florence will be saying on these, colleagues coming from because competition authorities are part of government authorities, government agencies. So maybe Wangombe and Florence may not be very happy with this statement, but I'll have the liberty of saying it. Most of our governments do not really appreciate the role that competition law plays in poverty alleviation and economic development. In fact, most of them is not a priority. So my challenge also is, how do we ensure that governments across the 21 member states appreciate the important role that competition law plays? Most of the time, they would want to circumvent or even assist businesses to evade that law in the name of your frustrating investment. We have seen that in a number of countries. Probably I'll not mention them here for purposes of diplomacy. But in the name of protecting investments, there are attempts of circumventing the competition laws for what I may term short-term gains. But what are the long-term damages and harm to the market? That is what they don't see. And I've coined up some phrase, okay? Some phrase that I'm saying, this subordination of competition law enforcement to anti-competitive conduct is actually not only injurious to consumers, not only injurious to our economies, not only injurious to our governments, but actually it is corrupt and morally indefensible. Because who should we look out for to a large extent? Should it be the businesses who are already in a better place, or should it be the consumers who are affected by that conduct of business? So should we sacrifice looking at the welfare of our consumers at the expense of the so-called investment? And I can assure you, Tamara, I know you are an attorney for private players, but I can assure you, those private players, those companies, even when competition regulation was at its peak, they would still invest. They are investing in the European Union, they are investing in America, where competition law enforcement is very robust. It does not make sense to come and say, because of competition law enforcement, we are frustrating investments and these businesses are not coming. So I find those arguments by governments a little bit corrupt, sorry to use this term, but also morally indefensible, because I think naturally you should actually fight for those people who are in a weaker position than those who have a better position. And then finally, maybe on this issue, Tamara, the other challenge is what role will the COMESA Competition Commission play in contributing to the reduction of food prices in the common market and probably beyond? Because this is one thing that we've seen across board in all the member states, that food prices are skyrocketing. Food inflation is disastrous. What role will the Commission play to ensuring that this happens? And already, as I hinted, we have this Africa Market Observatory where we've identified a number of issues, if addressed, that may at least reduce pressure on skyrocketing prices and probably bring them down, or at least maintain them for some period of time. And our approach there, or our intention, is that once the study is done, once the research is finalized, we intend to invite ministers of trade and ministers of agriculture, or at least permanent secretaries at that high level, those who are responsible for policy. We bring them together, make this presentation, show them what we've identified as problems. So I think for now, those are the immediate challenges, Tamara. And yeah, we hope we will overcome those challenges with the help of all of you and colleagues on this podcast, like Wangombe Kariuki, and of course, Florence, even if she's very far from COMESA. Thank you so much.
Thank you, Dr. Mwemba. That's very insightful and much appreciated. We do want to go over to Wangombe, but just before we do, I was wondering, are we expecting changes to the COMESA competition regulations? I think at some stage it was anticipated that they would be amended this year. You know, I'm asking for my own selfish reasons as a competition lawyer, wondering when that suspensory regime is going to be kicking in.
No, that is very correct. We expect a number of changes. The review of that law is actually at an advanced stage. I think by February next year, in fact, we'll be calling for stakeholder consultations. I think we need to have a number of them, maybe 2 or 3, in different member states. And again, we invite stakeholders, just like we used to do on guidelines. You recall, we would invite a number of your stakeholders to make comments on that. So yes, the law is under review. It has reached an advanced stage. Come February next year, we take it for stakeholder consultation, and then November next year, we hopefully we have a new law. There are a few issues that are there. For example, when it comes to mergers, the COMESA law is not very clear on whether it is suspensory or non-suspensory. It's there's a lot of gray area there, and the interpretation is that you cannot implement that merger before notification. But once you notify, actually it is silent on what happens. So others have argued that you can actually implement it as long as you've notified. So we are removing that uncertainty to make it clearly suspensory. You cannot implement before the decision of the commission. And then there's this problem also. I think Tamara and a number of other lawyers, we've had a number of discussions around that issue. The 30-day period within which to notify after making a decision. We thought that has brought more problems than the benefit that was envisaged. So that, again, is coming out. And then also what we learned in practice was during at the time of the Microsoft Activision merger, the commission attempted to intervene in that merger, but the parties reminded us, and rightly so, by responding and saying, look, your regulations do not give you the authority to intervene in this merger, because your regulations are quite very clear that if a merger does not meet certain thresholds, then you can't intervene. And in that case, obviously, it's a digital market sector. So they did not meet the thresholds, but that's not the main issue of consideration in digital markets now. So clearly, they could not notify that transaction. Of course, others have argued that we could have used Article 23.6, which says even if a transaction does not meet the thresholds, you can still call for a notification. But we also want to be an institution that is that creates predictability and certainty in the market. Article 23.6 is very clear. It says if you have to use that, it should be in extremely rare circumstances, and you should demonstrate actually that the anti-competitive concerns or effects are very imminent. And we did not have that immediately on our hands in the Activision Microsoft merger. So we did not want to create that impression again to the market that when we just feel like we can easily say 23.6 for any transaction, even if it's not notifiable, bring in. So we are bringing in new provisions that will make it very easy for us to intervene in the digital market sector. So that is about the law. Of course, a number of other provisions also for restrictive business practices as well. If you look at our law, again, there's an Article 19 that talks about hardcore cartels, but it does not say clearly that these are per se prohibitions that immediately they're established, then there's no defense. Again, there it leaves a gray area. It simply says these are prohibited, but it does not say whether they are per se offenses or... So the commission has attempted to categorize them as per se offenses in the guidelines, but others have argued that the guidelines have gone a little way beyond what the law states, and they are illegal. So again, we want to make it very clear which conduct is considered per se, which conduct may be considered rule of reason, and a number of other issues also. The law, again, Mr. Kariuki, our law for investigations, including cartel investigations, Florence, they talk about a total of 180 days, that the commission has a total of 180 days within which to conclude such investigation. And now that is a joke. How a cartel investigation cannot, especially at Mount State. So we are reviewing all those things. But apart from the law, Tamara, before I leave the floor, apart from the law, currently we are also now focusing more on cartels. As I said, we are moving from being major centric, focusing more on cartels, but also on other restrictive agreements, especially vertical ones. Now, there was this theory in the late 90s, early 2000s that vertical agreements actually did not cause much harm compared to horizontal agreement. We are beginning to challenge that theory at COMESA, especially when you talk about the accumulation of these vertical agreements by dominant firms operating in different countries. We foresee a situation where these vertical arrangements, which seemingly are not considered so negative compared to horizontal agreement, are creating a situation where markets are isolated, or markets, what's the word, are partitioning of markets, not because maybe that's the intention of the parties, but the cumulative effect of all these vertical agreements by dominant firms in different member states ultimately results in the partitioning of the market, which is significantly anti-competitive and against the treaty, because the treaty talks about integration. So those are some of the things that we are looking up to. But in conclusion, and I've always said this, maybe let me take this opportunity once again to reiterate this, that the COMESA Competition Commission is not an enemy of business. No. Okay, competition authorities are not enemies of business. Competition authorities simply want a competitive environment where all businesses thrive. So in that respect, we are actually friends of business. We want a fair platform for everyone. So those that feel they are being targeted, no, they are not being targeted. They are being approached because there's something wrong that they are doing, which is not to the advantage or which is to the detriment of other businesses that may want to thrive properly in a similar environment. So we are not enemies. We are friends of business, actually. And as I've always said, those who think actually their conduct may be found wanting may do well to approach the COMESA Competition Commission so that the matter is easily resolved and settled before it escalates. Thank you very much, ma'am.
Thank you very much, Dr. Mwemba. Great to hear from you, and that's very insightful and helpful. I think we can now ask Mr. Wangombe Kariuki for his thoughts on what is shaping and driving competition law enforcement in the region and generally in Africa, now and in the future. Wangombe, I know that's something that you've given some thought to, so I'd like to hand over to you.
Thank you, Tamara. In fact, I haven't given a thought to it, but when Willard was discussing, I picked 2 or 3 issues which has solidified what is in my mind. And one thing which has come out very clearly is that this is the same COMESA which vilified Wangombe 10 years ago. I know it's the same COMESA which is saying Wangombe was talking sense. So what I'm trying to say is that what I'm seeing shaping the competition enforcement and regulation in Africa, it is leadership at institutional level, and also leadership at government level. And to the people who are listening, is that we've had change of leadership in Kenya, that is Competition Authority of Kenya. We've had change of leadership in Competition Commission of South Africa. We've had change of leadership in COMESA in the recent past and in Tanzania. And if you look at the history since that leadership came in or came out, is that you can see that there has been some changes. And therefore, is that I expect leadership to drive the enforcement of competition in East Africa, in Africa, and in the whole region. Number 2, it's also in terms of political leadership. Willard talked about, that some governments, they don't appreciate the role of competition in driving poverty away. We've had change of leadership. We have the President Ruto's government, which now in Kenya is focusing on small, medium enterprises. I know in South Africa, this is the last year of Ramaphosa's government. The new government, even if it's Ramaphosa's, obviously he'll come up with his own other policies. And competition agencies, they always align their priorities with the government agenda. I know there's the government of Tinubu. Florence will tell us about what Tinubu's government is focusing on. And in 2025, we are expecting also elections with the government of Suluhu in Tanzania. And that is that it's going to change the dynamics of competition enforcement in this region. And also, as I've indicated, in Nigeria, we might see some changes, and South Africa, I think we've already seen some changes, and we expect some more changes after the elections of 2024. The other area I'm seeing driving the agenda, it's in terms of development of national laws, continuous development of national laws in countries which did not have competition laws. In Uganda, already we have a bill which has been presented to the president. He had his own reservations, it was returned. It is an advanced stage. So in the next few years, Uganda is going to join the league. Then we have Rwanda, which has a law, a very expansive law, and we are going to see the agency being resourced. And therefore, what I'm trying to say is, apart from the 44 national competition agencies in Africa, they are continuously expanding. And not only at national level, we have also the East African Community Competition Authority, which we expect to be on board by 1st of January 2024. Not, of course, and later I'll come to this, the African Continental Free Trade Area, which is supposed to be on board in the next 5 years. So the institutional development and the laws development is very, very key. The other area is that which is going to drive the enforcement is that there has been a lot of increased cooperation in terms of enforcement and in terms of also intention to enforce. I've seen 2 memorandum of understanding signed by COMESA and the other 4 African countries, I think 5, in regard to how to address digital economy and emerging markets. And this cooperation, obviously, it may lead to what I may call convergence, not only in terms of the law, but also in terms of analysis in some markets, in how they approach the digital economy and also how they analyze the digital economy. The other area, and Willard has mentioned about it, it's in regard to the increased role of market inquiries and joint studies. I think it's because, and Willard, sorry, I think competition agencies, they are facing a lot of resource challenges because due to the austerity measures, and they have to cooperate in terms of joint studies so that they can save resources. And this cooperation of joint studies, it is building capacity, and therefore we expect more development of skills and capacity and cohesion in terms of the investigations. The other area I'm seeing, I think after COVID-19, governments have started appreciating the role of competition policy, or even maybe not understanding, but taking all the problems to the competition authority, thinking that there is a savior. And we have seen the expansion of competition laws beyond the normal scope, we think, of competition law. We started with Kenya abuse of buyer power. I see that we have expanded now to, we are moving towards superior bargaining possession, which is going also to cover economic dependence and gatekeeping. I've seen also, because of austerity measures, authorities now, they are being given the role of consumer protection, and we might start seeing collapsing of the roofs to have one mega regulators. Generally, that is what I'm seeing, what is shaping enforcement of competition as we move forward.
Tamara, just before you come in, I think Mr. Wangombe raises a very important issue that we are progressively seeing competition authorities, in fact, being given other roles because they are seen probably to be the saviors. And he mentions Kenya. I think in your own country, South Africa, we see that a lot as well. I don't know what Mr. Kariuki will have to say on this later on. Is that not also going in the dangerous zone that competition authorities may end up becoming overly intrusive, going into the mandate for which they are not specially designed? I think it's food for thought, Mr. Wangombe. You are the expert in that one. You may talk about it at some point. But Tamara, I apologize for for intervening here.
I'll conclude by that.
Thank you, Wangombe, and great observations, Dr. Mwemba. Thank you. Mr. Kariuki commented on it or alluded to it, but I'd like us to go back to it. So the African Continental Free Trade Area, the competition protocol was adopted earlier this year. And as far as I know, that ushers in a new era of competition law enforcement on the continent. Just how that's going to play out exactly is not something I'm aware of. But I wondered if you had any thoughts on how this new competition law framework, if that's what I can call it, offers opportunities and potential challenges that can that may impact effective enforcement.
Thank you, Tamara. My views regarding the African Continental Competition Protocol is it upholds and provides for the traditional tenets of competition regulation. That is mergers, restrictive trade practices, and abuse of dominance, the traditional tenets. But it goes further to provide for what I call novel provisions, especially Article 12, which it creates provisions in regard to gatekeeping and economic dependence. And it does not go far away from what the competition agencies appreciate in competition analysis, but it creates another new layer, an institutional dispensation, which we need to look at what I may call the optimal stairway joinery to join the national competition agencies, regional economic communities, and the roof, which is the African Continental Competition Authority, which is being envisaged. We have to appreciate that having a free trade area creates very good opportunities for businesses, a population of 1.4 billion, a GDP of 3.4 trillion US dollars, and a market served by 44 competition agencies. And this competition policy, when it's brought on board, it will have, and it has indicated that it is going to be domesticated in the whole free trade area. And therefore, I'm seeing an opportunity for modernizing and building capacity in agencies which they don't have that capacity, and for businesses where Willard was indicating, creating predictability and certainty, because some agencies in Africa, they are just operational but not functional. I see them more in conferences than in decision-making. And I think it's important that they are given a job to wake up and do what is their role in terms of ensuring that the markets are free for each and everybody who plays in those markets. And I see the African Continental Agency having that role. And it is a step further that it has created timelines that countries which they don't have competition agencies, they should create competition agencies within a timeline, I think about 5 years, then the other ones which have competition agencies, they have to domesticate their laws as per the provisions of the African Continental Competition Policy. That's a way forward. And it comes at a time when they can learn from the problems we had Kenya and COMESA. You know, those challenges, they can be attended from there. And when now I talk about the challenges, obviously, there are some challenges I'm anticipating. And the biggest challenge I see when you look at the treaty itself, the agreement, is that it talks about that it will move with the what we call principle of variable geometry, and number two, principle of a quiz. Principle of variable geometry is if you can't move with the speed of the others, you're allowed to move slowly. So that rugged terrain is that still it is going to be there, that people have been given that opportunity still to lag behind. Number two, the principle of a quiz is that it does not want to dismantle the current framework, even if, sorry to use term, that it's ineffective. So it is giving with one hand and taking with the other hand. But I think this was the issue of trying to assuage each and every negotiator. Then when it comes now to the protocol itself, it creates a window that a country can come up with can still maintain policies if at all it's for strategic nature. And therefore a country can come up and say, our policy is to support the marginalized in the northern Kenya. And even if it's affecting competition, now that one will not be touched. So that is a challenge I'm seeing. The other challenge I'm seeing, Tamara, it's in terms of how the geographic markets are going to be defined. What will be the, I know it has talked about the principle of a quiz, and it will relate to the regional economic communities, and the regional economic communities also will liaise with the national competition agencies. But there's a challenge. Our dear brothers in South Africa, they have not been in a regional community. And I wonder how now they'll be treated in this, interfacing of this regulatory intercourse as we move forward. Taking into account also, 50% of the biggest firms in Africa are based in South Africa. Is South Africa going to be given a special focus by the African Continental Free Trade Area, or it will just be any merger emanating from South Africa will be treated just like any other merger emanating from my country, Djibouti? I think these are questions we need to ask ourselves. Then the other challenge I'm seeing, it's in terms of domesticating the new economy emerging, Article 12, which provides for economic dependence. As I indicated, I've seen cooperation or intention to cooperate in digital economy and platforms. There was the first one signed in, I think it was in Santon, another one signed in Cairo, but I've not seen credible infantry on the ground trying to regulate this. So there's some intention, but what I've come to appreciate is that these are very new, novel areas where we might not be having resources in agencies, where we may not be appreciating the market, and therefore domesticating that article in the first place will be very, very difficult. I think that is the challenge I'm seeing. And the other challenge is in terms of dispute resolution mechanism. We have Commonwealth system in Africa. We have French, and I think also we have some kind of Maghreb and also Dutch. How do we harmonize this when it comes to dispute resolution, especially in the competition tribunal? I think this will be another round of discussion, and I'm happy. I've seen that there will be regulations which will be developed, and I think they're in the process of starting that. And I think this is where we really need to be keen on.
Thank you, Wangombe. That is certainly a lot of food for thought. Thank you very much. I do have a question for you, but I think just in the interests of time, we should probably move across to West Africa. For those who have joined more recently, we are joined by Ms. Florence Abebe, the Chief Legal Officer from the Nigerian FCCPC. And welcome again, Florence.
Thank you very much. Thank you for having me, and it's such a pleasure to be here.
And I am pleased to see that you have been at the regulator since 2019 when it started. So you are very well placed to talk about what has happened, what has worked well, and more significantly, what are we expecting in the future? And you do know that I would not miss the opportunity to ask if we will be able to see any amendments to the thresholds for merger notifications and possibly an introduction of a cap on filing fees. But over to you, Florence, to tell us what has been happening in Nigeria and what we should expect to see next.
Thank you very much, Tamara. As you know, already alluded to by His Excellency, Dr. Wemba, the Federal Competition and Consumer Protection Commission is an agency of the federal government of Nigeria. And we are, just like in most competition authorities, we're responsible for protecting and promoting the interest and welfare of consumers, as well as prohibiting unethical, unfair, and restrictive business practices. Essentially, the Commission has a dual mandate of protecting consumers and promoting competition. And like most competition authorities, our objectives are the same. We are administering the enabling law, which is the Federal Competition and Consumer Protection Act. We are also administering any law in Nigeria that has to do with consumer protection, even if it's not domiciled at the FCCPC. Any law that has to do with consumer protection or competition, we will deploy our tools to enforce those laws. To be more specific, we look into prohibiting anti-competitive practices such as cartels, abuse of dominance, any practice that restricts or stifles competition or deprives consumers of the well-discussed benefits of competition, whether it's price, choice, quality, or even speedy redress. And so we also look into coordination of businesses, whether it's mergers and acquisition, just to ensure that we're not substantively preventing or lessening competition in any way. We're not strengthening a dominant player. So we do all these applying several tools, whether it's ex ante or ex post, through regulations, advocacy, policy development, market studies, investigations, and enforcement. And with respect to what we're doing and going forward, you can expect a lot more activities from the Commission. I had mentioned to Tamara earlier when I announced on my LinkedIn page that I was going to be speaking at the Brown Bag with the ABA. A lot of people were very interested. I do recognize that Nigeria is a country that people are looking at to see what's going on there. And so, yes, you can expect a lot of activities from Nigeria. And we have had to prioritize our activities based on the objectives of the law and the Commission, as well as our available resources. And what may be helpful to understand our activities and the way we carry out our work is our institutional history. Just as we've said here, the law came into force in 2019. So we're almost 5 years old. However, prior to that, we were the Consumer Protection Council, and we had a single mandate at the time. Now we have a dual mandate, and so we have to deploy resources to prioritize issues we consider more important. For example, here at the Commission, we have prioritized anything that directly or immediately impacts or harms consumers' interests. And so we started off with creating this regulatory certainty that Mr. Francis and Mr. Wemba have spoken about by coming out with key regulations, designating the regulatory roadmap of the Commission's activity as important. And so we've come up with several regulations, abuse of dominance, restrictive agreement, measure review regulations, leniency, etc. And what we tried to do is to make sure that we had enough information out there. We've published this information. We're giving people the opportunity to understand the activities of the Commission. We have also entered into several memorandums of understanding with sector-specific regulators here in Nigeria, as well as other MOUs with other international competition agencies. And this is to ensure that, there are limited or little, if not zero, market disruptions. We've also prioritized certain sectors, such as the digital market, and this would therefore involve a lot of collaborative work. And so you can see the importance of those MOUs. It would also involve a lot of market studies. We did some market study in the aviation sector. We're hoping to do a lot more. We're currently working with other international bodies to do market studies in the digital sector. We're hoping to do some in the pharmaceutical sector. And just like that, we're going to be discussing a lot with professionals, association levels, as well as sector-specific regulators. We will continue our enforcement activities. We are currently investigating certain digital money lending businesses. We're looking into privacy and data protection issues. We also hope to see more with respect to price gouging, given the very problems that we're having with inflation in the country. We're also doing a lot of exemptions. We're considering a lot of exemptions in certain specific markets. So yes, you will be seeing more investigations, more dawn raids, and of course we're prioritizing internal capacity development for key departments here at the Commission. And I know that Tamara is keenly interested in the merger department. Our thresholds have remained the same with respect to mergers since we promulgated it in 2020. We had to take into considerations feedback from different organizations such as the MBA, the IBA, and a lot of firms in deciding on this threshold. Nigeria is a unique market, and so we have to take into considerations those unique characteristics and specifics that relate to Nigeria as a client when we decided on the threshold. We recognize that compared to other more established, more developed competition agencies around the globe, where they have readily available and credible data and more stable economies, that the Nigerian measured threshold is considered generally low. However, the rationale is, besides the fact that we are a budding competition agency, and we also need to gather that exposure, gather and harvest the much needed credible data so that we can understand the market, its structures, the participants, and all the other counterfactuals. And so we've decided to keep the thresholds low until we are, a more mature agency. And in Nigeria, as you may be aware, only the large mergers are allowed or are mandatory for notification. And so we really don't want to miss out too much on what we now consider to be small mergers. And so we have had to keep this threshold low just so that we can trap as much as we can. Now, with respect to fees, which I know is also of interest, the Commission is still considering whether or not it's going to cap its fees. However, the best that has gone on right now is the revision in 2021, where the Commission decided to review and reduce its merger filing fees.
Thank you very much, Florence. That's very helpful. And there may be people who have questions, so I'd encourage anyone to include questions that you may have either by raising your hand or including a question in the chat. And maybe just while we have Amanda, and we're conscious of time, Amanda, I introduced you in your absence. So for those who have joined more recently, Amanda has been speaking at a conference and has kindly made himself available to join us. So welcome, Amanda. Amanda Mfupi is a partner at the Bowman's Competition Practice based in South Africa. He's also a former member of the Mergers Division of the South African Competition Commission, and speaks to us at a time in which things have been very busy in the competition space in South Africa. So our competition authorities, for those non-South African listeners, have been focusing on the public interest quite significantly, especially since 2019, when amendments were made to the Competition Act that placed the public interest assessment on a par with the competition assessment. And this touches on Dr. Mwemba's earlier comments about what do we think is really within the domain of the competition authorities and what arguably should not be. And certainly South Africa has been either famous or infamous, whichever way one would like to look at it, for taking the public interest very much as part of its assessment of mergers. And similar considerations play out also in the space of investigation of horizontal conduct. Now, the draft revised public interest guidelines that have been published very recently by the South African Competition Commission and are out for comment, they reflect certain positions that are fairly controversial, I think, especially as far as the promotion of a greater spirit of ownership is concerned. And I'm going to ask if Amanda would like to talk to us or talk us through that. Welcome, Amanda.
Well, good afternoon, Tam, and afternoon to everyone. Thanks for the invite and the opportunity. Sorry for joining late. As you mentioned, I was at another panel here at the ICN. But just as an opening remark, Tam, I think we can all acknowledge that public interest issues will continue to become a great component of traditional competition assessments across the continent. And we see this trend that is gaining momentum. However, I think it's also important maybe just to point out from the outset that this is not necessarily unique to the South African context, for instance, as we have observed that in other jurisdictions like the US, we see authorities as well as the government in those parts of the world invoking national security assessment provisions to intervene in mergers, which may sometimes seem a bit opaque. Whereas compared to South Africa, where these are listed in the legislation, as well as the parameters in which the competition regulators can actually intervene on public interest grounds. Even though as legal practitioners, we broadly differ with the Commission's interpretation, especially of late, but I mean, at least there's some certainty on the parameters in which the Commission has to assess mergers on in terms of public interest. So in South Africa, public interest has always been in our law since the inception of the Competition Act, and this is largely informed by the past discriminatory laws that excluded a majority of the population from economic participation. And as we would all, perhaps maybe those who have practiced longer than I have, they would recall that at some point the regulator was particularly focused on employment as well as job preservation due to high levels of unemployment in the country. And they tried to have interventions through merger regulations by imposing moratoriums as a result of potential job duplications in merging firms. And I think during that period, what we saw a very good body of case law that sort of gave guidance on when the commission can intervene and impose conditions on employment-related concerns due to the contestation between merging parties and competition authorities on when the commission can intervene on employment. Fast forward to 2019, the Competition Act was amended, and the Competition Act added a fifth public interest factor that the commission has to consider as part of its assessment of mergers. At the outset, the amendments, they confirmed the position, I think, that was already widely held by the commission, that competition assessment as well as public interest assessment bears the same weight in merger assessment regulation. However, the Act codified that. So I think we are all in line in relation to that weighting. Just on the specific provision, which I think has everyone in South Africa quite interested and in the world, because I think it's still a new provision that we are all grappling with, or rather the commission is also grappling with how it's going to implement. The provision indicates that as part of a basket of issues that the commission must assess, it now has to assess the effect of a merger on the promotion of a greater spread of ownership, in particular to increase the levels of ownership by historically disadvantaged persons and workers in the market, right? So since the introduction of these amendments, the Competition Commission has inconsistently applied this new provision, whereas in some transactions, we observed that they would require parties to promote a greater spread of ownership by requiring merging parties to commit to establishing an ESOP with the magic number of 5%, wherein they give equity to employees for 5%. And in other transactions, the commission would simply not require this of other merging parties. I mean, depending on which investigation team's desk your merger lands on, right? So, however, last year, if I'm not mistaken, we observed that in the last financial year, there were an increased number of these requests that came through from the commission, wherein the commission's investigation team would write to the parties at the onset to ask how a merger promotes a greater spread of ownership for HDPs as well as employees. And so largely in response to, I think, requests for certainty from legal practitioners in South Africa, the Competition Commission finally issued draft guidelines or revised draft guidelines, which reflects its policy approach on how it interprets the new provision. And the Competition Commission has interpreted this provision in essence to mean that every merger transaction that is before it must have a positive impact on the increase of a greater spread of ownership as it relates to employees as well as historically disadvantaged persons. And the commission has advised that its interpretation is largely informed by the introduction of the term promotion in that specific subsection of the Act. And so what we saw in the merger guidelines is quite a very I think it was, I'm not sure if unsettling is the right word, but what we saw is quite a robust policy position from the Competition Commission, I think which we've observed, but now it's sort of been put in formal writing, wherein the Commission has categorically expressed that if a transaction that is filed by merging parties does not promote a greater spread of ownership for workers or historically disadvantaged persons, they view that merger transaction as having a negative effect on the public interest in South Africa, and not just a negative effect, but they view that as a significant negative effect on public interest. And so they call on parties to remedy those type of transactions through providing remedies that would address that concern that the Commission identifies. And I mean, just anecdotally, Tam, I was actually reading the Commission's annual report for the financial year 2022 and 2023, and the Commission has added as a sixth KPI indicator in its performance review that it has to implement or approve mergers subject to these ESOP and HDP conditions. At least 5% of mergers have to be approved subject to those conditions, which means that now it's a performance target for the Commission. And obviously it also has performance related and financial related implications for the investigators of the Commission, particularly in the mergers and acquisitions division. And last year they exceeded this target. They approved conditions subject to ESOP and HDP conditions. 28% of the mergers were approved. So that's just an indication that the Commission is implementing these guidelines in a manner as articulated in its draft guidelines. The draft guidelines, obviously, they are still in draft form, and all interested stakeholders have a chance to comment on these. However, even after adoption, these will not be binding, but they do serve an important role because they serve to outline the Competition Commission's approach on how it would assess mergers going forward. And I think, just as with employment, I think we may need a good body of case law to sort of assist the regulator unpack how it should be interpreting this clause, because it will certainly have an impact on mergers being filed in South Africa. And I think we are hoping that all the interested stakeholders will comment on the draft guidelines in order to make their input on their observations relating to the Commission's approach. So that's just on the public interest, Tam. Thank you.
Thanks very much, Amanda. And I can tell that you've looked very closely at the guidelines already. And thanks for your insights there. I think also, just recently, if not today or yesterday, the South African Competition Commission has initiated another market inquiry. So it's initiated multiple market inquiries recently, concluding one this year. And on my count, I believe another 4 are underway. Amanda, do you want to give us your thoughts about this, having been at the Commission and now not at the Commission? Be interested to hear.
Sure, thanks, Tam. Yeah, I think when I was at the Commission, there was a handful of market inquiries. But I mean, I think market inquiries I was actually in preparation for the session that I just had, I was reminded of a concept paper the Commission issued in relation to how it intends to assess competition in digital markets. And even in that document, as far back as 2020, 2021, the Commission highlighted that it views market inquiries rather as representing an effective tool for them to promote and retain competition in markets where there are common industry practices which may collectively contribute to hindering competition. So I think we're going to see a lot of market inquiries for specific industries that the Commission has identified as potentially problematic. And this is coupled with, you would recall that the Commission has also released 2 years ago, if I'm not mistaken, the concentration market study. So the Commission is working in a very, I would say, deliberate manner in order to try and uncover what it feels are features of a market that hinder competition. And I think market inquiries for the Commission, or they view it as an easy win, if I were to say that, because I think the standard expected of there is not a similar standard you would expect of a market conduct case, wherein the Commission has a certain standard to prove unilateral effects, or for instance, competition harm. So it's really an easy win for the Commission, and they view the remedial actions that the Act confers upon them as binding. So I think we're going to see a lot of these market inquiries, particularly with resource constraints as well, as mentioned by the other panel members.
Thanks, Amanda. It certainly seems like that. And from having spoken to one or two senior members of the Competition Commission, you know, when you do, you get a different perspective from that which you would have as a private practice lawyer. And I think us in private practice and our clients often find market inquiries as potentially very invasive, difficult to defend and predict. But I can also appreciate the regulator's view that it's a way to look more deeply into something that may present a problem and to try and resolve issues that are maybe not just resolved in the ordinary course by litigation. So I agree. It certainly seems that we'll be seeing more of those. And with that, I'd like to put to you, possibly unfairly, because I think it's a difficult question, but would you say that the competition law regime in South Africa is becoming less predictable? I mean, we mentioned the guidelines, and I think it's always helpful to have a document that articulates a regulator's position so that we have a sense. But currently, how would you say we are seeing the predictability of the competition law regime in South Africa?
Yeah, it's a very difficult question, Tam. I mean, but just maybe I wouldn't say it's becoming less predictable. I think maybe the guidelines help to mitigate that unpredictability. I think, I mean, it's something that we all appreciate, that I think in South Africa the scope of the public interest debate has in and of itself become hugely topical in South Africa. And I think we as a society are still grappling with the measures that need to be taken, or rather undertaken, to address the public interest, especially because of our historical economic exclusion for a large sector of the population. And I think the government sees competition law as one of the tools in its arsenal to try and address these complex, societal issues that we are all, I think we all recognize, and they want to do this particularly through merger regulation. I think the problem or the difficulty then becomes that you are really focusing this type of transformation on a very small number of transactions that come before you. So it's not really a law of true general application that seeks to transform society. So I think it's a complex issue. It's political as well, in as much as it happens in our space as legal practitioners in the competition space. But I think it is an important issue that government and state agents like the Commission are still grappling with. So I think for me, I mean, what I would say is that I think companies that do wish to do business in South Africa should have this at the front of their minds, that there's a presence of these public interest imperatives and these conditions, and one needs to think a bit deeper about them when they contemplate doing transactions into South Africa. And I think take them into account and not be sort of surprised when they come into the country. Certainly, it's going to be a very interesting couple of months while we grapple and while we comment on these guidelines. But at least the Commission has shown us their hand, and I think it's incumbent on all the interested stakeholders to comment. That's why these are public documents. It's important that everyone comments on them in order to try and dissuade the Commission should they not be happy with what's currently in the draft guidelines.
Thanks, Amanda. I just wanted to see if we may have any questions. I know that we we've had quite a long session. I think I see a hand.
I think, Tamara, before you go to the questions, there's a question Willard asked me in regard to the government's putting a lot of weight on competition agencies, and what are my thoughts on that? And I can say it's a curveball, but it's something I've been thinking about. I've been thinking that there's a time we need to relook at how competition enforcement is done in Africa, especially in this era where we are moving from the economies being driven by the traditional markets and moving to ecosystems. I'm of the opinion now that we need to have kind of a multi-agency approach to competition regulation, because markets are cutting across all the sectors. And according, like, for example, Kenya, the Kenyan's country economic memorandum, which was released by the World Bank yesterday, Kenya is a service-driven economy. It has jumped the industrialization part to service-driven. And therefore, now we are not looking at specific markets, we are looking at ecosystems. And telling the competition agency just to drive this agenda alone, it becomes more complicated. So I think we really need to look at a multi-agency approach. Then the other area we need to look at is there's also the threat of state-owned enterprises creeping in, especially after COVID-19, and also the government to tackle the climatic changes and climate sustainability, especially the green energy. We are seeing business of the state increasing. That is another threat to competition enforcement. Still, we need to develop what I may call a competition policy and document it and highlight these are the areas and this is the approach we shall be taking in regard to competition regulation. I wanted to make that clarification. Willard threw it to me.
Thank you, Ngambe. I just wanted to see if anybody has any questions, and I see a hand. I think it's Mutugi.
Yeah, thanks, Tam. I have just not directed at anybody in particular, but okay, first of all, I'm Mutugi Mutagi from Bowman's, Kenya. And I just wanted to ask this with respect to market inquiries. because something I've always grappled with for the past couple of years working the competition field is when the reports come out, say if it's from the Competition Authority or of Kenya or it's the Competition Commission South Africa, you will find a circumstance where some of the recommendations in there are either very tough to implement. Let's say, for example, they actually have to go through a legislative process, or in some cases are prone to significant litigation before they actually make any traction or are actually implemented. And to that end, I've always wondered about what the utility to a certain extent of market inquiries is, in as much as we've just discussed, they can be seen as not an easy win, because definitely they're not easy to achieve, but they're a better way to understand an industry and go in depth. But I think this just to end, maybe those who Dr. Willard or Mr. Ngombe or forget yes, Mr. Florence, from your view, do you think there's an alternative way around into how the actual output of market inquiries can be made more viable? To at least, I don't know, it's something about how to actually get the actual content of the report to actually be implemented.
Thank you, Matugi. I couldn't hear you very well, but it may have just been the sound on my side. Are any of the participants? Wangombe, I'm not sure if you heard Matugi's question.
Mutugi, I think, is aware with the Kenyan provisions of market inquiry. but anyway, I think market inquiries are driven specifically with what is provided within the Competition Act of the specific country. In Kenya, and during my tenure, is that market inquiries were always focused on areas which the authority is not understanding, and therefore it would like to appreciate the market and see whether there are any regulatory gaps. And if at all there are regulatory gaps, can we come up with a regulatory regime which is supportive of developing that market and also protecting the players and the consumers. Then the other route we were taking, especially in terms of market inquiries, it's also to advise the government in terms of also those markets may be curtailed by regulatory obstacles pertaining in those markets. So also it's to advise the government. Then the third reason, the objective, was to check whether there are any competitive or restrictive trade practices which require the attention of the law, and we deployed the law. But we couldn't deploy the law without following the whole investigations and coming up with the final decisions. That is as far as the Kenyan law pertains. I don't want to talk about the other regimes, but also in Kenya, after a report comes out, some of the players, they could see that where the direction is heading to, they might be found culpable. And they could approach the authority and seek to come up with solutions even before the authority starts the investigations. So I don't know whether I've answered Mutugi's question.
Thank you, Ngombe. To jump in if he wants to, but Lawrence wanted to give her views.
Yes, and I think that Mr. Wangombe has said it. Usually when we do these market studies, we usually engage the operators. And so they have an opportunity to contribute to the study in a less aggressive manner as opposed to if we were investigating. And so this is an opportunity for them to come out clean, open up, and be willing to provide much more information than we know as regulators. And so usually when we approach it through a market study type thing, the chances that it would develop into an investigation that would be aggressive or is very slim. And that's because we have encouraged the businesses to come out transparent with us and willing to, you know, cooperate and provide effective regulatory process through all of this. And so obviously, just like Mr. Francis has said, when these studies come out, it is something that has come out of a collaborative exercise. And so we're looking for a solution that is efficient for all of the players, whether it is the regulator, it is the consumer, is the economy, or even the operators or sector-specific regulators. And so market studies are very efficient because they are less costly than an investigative process. And so it is encouraged that we go that route, and businesses usually prefer that route in terms of collaboration than an investigative process.
Thank you, Florence. Not sure if there are any other questions, but we have not much time left. So maybe if there are no other questions, I could just take the opportunity to give a big thank you to all of our distinguished speakers. It's really wonderful to have had your inputs today. Lovely to hear from you, Florence, in particular from Nigeria. Fantastic to see you, Dr. Mwemba, from COMESA, and be seeing you soon in Malawi. Lovely to see you all. Thank you, Wangombe, for participating, and especially to Amanda, who's had to go from one panel to this one after a long flight. Your participation, Amanda, and your insights are much appreciated. Thanks very much.
Thank you so much, Tamara, for having me.
Thanks, Tam.
Thank you so much, and see you soon.
Bye, everyone.
Bye-bye.